24 to 17. I'm Dave Anthony, and this is Fox News.
Lawrence County depends on WDXE News, on the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
It's time for Stan Pierchoski and Bulletproof Estate Planning. Stan, it's been a whole week.
It has. Good morning, Jeff.
Good morning to you.
This mic's a little hot.
It's your headphones, probably, because me and Joe turns them up.
Gotcha. Okay,
Yeah.
that's better.
There you go. Is that better?
Yeah, it's much better. How are you this morning?
Wonderful, wonderful.
You know, before you popped in and you were out for a few minutes, I was trying to carry everything out to the parking lot because it's so nice and cool out there. I thought we'd just do this out there, but it was a little heavy and I couldn't handle it.
It would be a beautiful day to do it outside, wouldn't it?
And I'd open a window if there was one in here.
Yeah, it is a gorgeous day. Of course, we don't have a window here, but yeah, it's a gorgeous day. Looking for a good weekend.
I think October has finally arrived.
October has arrived.
Oh, good
It sure has.
It'll probably be heating by the end of the month.
Oh, don't say that.
Yeah.
Don't say
It'll
that.
be before we know. We'll be complaining about the cold in no time.
Well, I like the fall. Fall is my favorite time of the year. It really, really is.
I do too.
And I think it is for a lot of people. But I like the change of seasons when they come anyway.
Yep, I do too.
Yeah. You got big plans for the fall?
Yeah, I got some renovations at the house I want to work on.
Yeah.
But other than that, there's always something to do. But
Oh, yeah.
No big gigantic projects to talk about, but always something to mess with.
Do you guys travel over the holidays or anything like that?
No, it's usually we got to the point where if anybody travels, they come to our place.
Yeah.
The family sort of congregates.
Yeah.
And at my place if we get together. For
You know, there's only so many more Fridays and Saturdays till Christmas.
Oh, don't say that. I won't say it's going to be heating soon if you don't say that.
And that's
how
right around the corner.
And that is how it sneaks up on you.
It really, really does.
It does. So, hey, listen, we're here at Bulletproof Estate Planning, where we talk about estate planning.
That's right.
Surprisingly enough.
Surprisingly enough,
And
that's right.
it's a call-in show, and we're going to give you the number. If you want to call in with a question or experience or anything, it's 931-766-9393. Now, first thing I want to mention is a seminar coming up, not till November the 22nd, so about 5 weeks out or so.
Yeah.
And it's going to be at the Williamson County Public Library in Franklin.
Okay.
It's a Saturday. It's going to be at 10 o'clock that Saturday. And, you know, you don't have to be from Franklin to come to it. I mean, when I have seminars, it seems like rarely wherever it is where the people come from. But,
Right.
But you know, it's we're going to call it Will's Trust in the Nursing Home, and that's what we're going to talk about. You know, I do a Nashville radio show, and so I have a lot of northerner type listeners, and I get calls from them, and they ask if I'm ever going to head up that direction. So
Yeah.
we'll probably do that twice a year up there.
Yeah.
I think this is the only one so far this year because the venue had changed and we had to find a new venue. But the public library, it'll be interesting. You said you've been there. I've not seen it, but I understand there's plenty of room.
It's a wonderful facility.
Yeah.
You'll enjoy that.
Yeah.
You sure will.
You know, if nobody shows, I'll find a good book to read.
Well, you could certainly do that.
Actually, if nobody shows, I'll probably give the
Yeah.
presentation anyway.
You could certainly do that, no doubt.
But we're expecting a pretty good crowd. We've already got quite a few signed up, to be honest with you.
Great, that's good.
Yeah. Never too early to sign up for them.
I actually heard you on one of the other Nashville stations. It was one of your promotions. I was listening to 99.7, and you're on there on Sunday nights. Is that right?
It is Sunday night, 8 o'clock to 9 o'clock on that Super Talk.
That's right. That's right. Out of Nashville.
Yeah.
Very good.
And I've been doing that for over 4 years.
Really?
Yeah.
You know, time flies. How long have you been doing it here?
Seems
It's been
it
at
seems
least-
like around June-ish it was 2.
2 years, right?
I mean, I've been here as long. I've been here as long as when you started being talk radio on this show.
That's true. That's true.
Changed from classic country to talk radio.
You know, time really does fly because that doesn't seem like that would have been 2 years ago, but I guess it could have been.
That's how you end up old all of a sudden. Well, the trick is, for the time that's gone by, you've done what you're supposed to do and done your best. Lived a good life. So, anyway, so I'll talk about the seminar again at the end.
Very good.
But, we had a pretty good week. We had another 10-care approval come through.
Okay.
We've still got a few in the hopper, but we got another one come through. It was pretty uneventful, and it's starting to make me wonder that things have changed a little bit on the 10-care end because it seemed like for a period of about 6 or 7 months we had a lot of pushback on almost every one.
Yeah.
Some kind of pushback on every one.
Yeah.
And I think this one is probably the last of 3 or 4 that I've reported that have kind of been relatively uneventful. I mean, the stuff that they've done was routine. You know, they always ask for a couple things. They ask for this, they ask for that.
Right.
They have a question or two. All these things seemed real routine on these last several. So
Oh, yeah.
maybe the pendulum's swinging the other way, and it's a little more. They're going to be reasonable for a while. But I'm sure after 6 months of this, it'll change back. You know? But anyway, that's always good news when we can call the family on a day and tell them that they've been approved.
That's awesome.
Yeah, I actually had several meetings this week for people interested in getting a loved one eligible. So we'll see how that goes. So there's always cases like that going, and those always are pretty ripe for something to talk about because
Yeah.
they all get treated so differently. You know,
Yes.
things come up, and I always like to share the things that come up, you know, to let people know if you have a loved one in long-term care or somebody headed that way soon, you know, it's a pretty daunting task to get them eligible.
It really is. More so than I would have ever anticipated.
Yeah. Actually, something that's got me wondering is I've had a fellow come to me just yesterday. I met with him yesterday. His ex-wife was in care, and I was concerned. He was telling me what the nursing home had told him. You know, I had him fill out a fact sheet, so I knew a pretty good picture of the finances and, you know, the income and resources, which is where we spend most of our time.
Yeah.
And he told him that, I looked at it and he said the facility told him that she's not eligible. And I looked at the sheet and I said, well, did they tell you why? Because technically she's not eligible at this moment, but it wouldn't be very difficult to get her there.
Yeah.
And surprising to me, they said she made too much income. And I
Yeah.
looked at her income and, you know, her income, you know, the income cap, you know, we're in an income cap state.
Yeah.
Our income is capped for eligibility. And right now, and it changes every January. So right now for 2025, it's $2,901. And it'll change in January again. But even if you're over that cap, you know, we can funnel it into what we call QIT, a qualified income trust. I think one time one of the callers asked about that.
Right.
And so there's a solution if you're over the cap, even though technically if you're over the cap, you're not eligible. But we have some common law or the court-made law that says if you're over the cap and you put what's over the cap into a qualified income trust, where whatever goes into that trust goes to the cost of care,
Right.
like the income goes to cost of care, you can be over the cap. It's a long-winded way of saying, yeah, the cap really doesn't mean anything. I mean, we can fix the cap.
We can fix it.
So income's never an issue, but it surprised me that they said that's the issue, and they gave him a number, and it was last year's number. And he said he even went online and looked it up. He said, I looked something up, and it looked to me like it was $2,901. I said, you're exactly right. And I said, they're exactly right if it were 2024.
Yes.
But it's not. And so it was just the wrong information that they told him. Now, I don't know. I just wonder what would happen if he didn't decide to seek out some other advice
Right.
and just took their word for it. Now, are they giving out legal information? Probably not. I mean, those numbers are published. It's not like, you know, but they're, you know, you expect the facility would be a little more on top of that kind of stuff, but they're not, and so we haven't been retained on that case, but it looks like we probably will. But we'll deal with it, and that's not an issue. It's not going to be an issue, and it just surprised me that was the information that he was given from a facility that should probably keep up with how the rules are for TennCare. Anyway,
Interesting.
so the application, the do-it-yourself application, is just not recommended because it is just such a quagmire. There's so many rules, regulations, obligations, deadlines, all that kind of stuff.
Yeah.
It's just difficult.
Yeah. Well, do you want to take a phone call from one of our regulars? We'll do it, I guess.
I always take phone calls.
That's right. Hey, good morning. How are you?
Yes, one of the things he said, there's so much information out there and there's contradictory. And according to what I pulled up, though, they gave the bill number, SBO 534 and HBO 817, which one's a Senate and it's about irrevocable trust and the changes that were either started in July 1 or December 1. And I was wondering if later, if he's not prepared today, I know he's prepared, but I mean prepared for somebody like me to understand what it means. There's things like recent legislation, new laws, largely clarifications, and two of them had to do with enhancements to existing trust laws, and one had to do with spendthrift clause limitations, and the other one had to do with capital gains taxes being affected. It was not state. But I just thought the tax implications, because it sounded to me like from what I read, and this was like an AI overview, you really needed to be talking to a CPA also if that was an issue. Just want to throw that out for something for the future.
All righty, all righty.
Did you write those bill numbers down?
Did not.
Okay, I think I know which one they are, but, you know, I vaguely remember those, and I looked at them, and I remember reading the one about the spendthrift clause, which, you know, there was nothing new. When we do an irrevocable trust, what makes it irrevocable is the spendthrift clause. The spendthrift clause. The spendthrift clause pretty much makes it so that the maker of the trust cannot benefit from the trust.
Yeah.
That's what gives you the creditor protection stuff. And there's language in there that says, the principal in this trust cannot be used for myself, my estate, or creditors of me, or creditors of my estate.
Okay.
That's not verbatim, but it's the four things it has to say, and that's the spendthrift clause. You know, the spendthrift clause is a confusing term. That's what it means, what I just said, but it's commonly used when you refer to a person called a spendthrift. It's a kind of slang term for somebody who blows through money.
Right.
Or doesn't responsibly uses money.
Right.
And so it's not a real good fit for that last definition, but people say it all the time.
They do.
It's kind of like the term "in the trust." You know, there is no such thing as "in the trust," but you know there's no meaning lost when you use it, even though that's not. You know, it's just the way people say it. So I will pull those up, hopefully. But there were several things in there. She mentioned there were enhancements. There are several things that enhanced the trust. Now, there's not much you can really do to existing trusts. But other than maybe enhance some of the provisions that already existed in law at the time. You can never change them to be detrimental and then go back and apply them to existing trusts. That's what they call ex post facto. Now, you can't go back in time.
Okay.
You can change something, but you change it from that day forward.
Right,
And,
right.
You know, here's another one of those common terms. People would consider that your grandfathered in.
Your grandfather.
And although that's not the word, the meaning is not lost.
That's
in
right.
other words, you know, good examples is 5-year look back rule. People always ask me, what happens if they change that to like 7 or 10?
Right.
And what if I do this trust and I put property in a trust and that triggers the 5-year rule? What happens if 2 years from now they change it? The answer is for everything going forward, it's that new time period.
Right.
But for you who have done it, it's not. You know what I mean? It stays the same because they can't go back in time and say, I mean, if they could say, okay, go back to 1965 when
Right.
the Medicaid Act was written, and from that time forward, everybody's dealing with a 20-year look-back rule. You know, now everybody that's got property that's not subject to the rule is now subject to it because they just changed it. They can't do that. So that's the same thing. But enhancing some of the stuff, you change the law that's a little more beneficial. Now,
Sure.
it escapes me, and I'm glad she gave me till future time to deal with it because I did not. I'm just shooting from memory, and I did look at that, but it was back in July, back when I was talking about the One Big Beautiful Bill and some of the things that were going on with that. So,
Right, right.
now, that was not in the One Big Beautiful Bill.
No.
But surprisingly, that went into effect on July the 4th, if you remember.
Yes.
But she mentioned July the 1st. And that's true because in Tennessee, laws go into effect only 2 days, January 1st or July 1st. So
Okay.
like right now, here we are at mid-October.
Right.
If something was being passed, a law, any law, and the legislature, you know, the Congress signed off on it, the Tennessee legislature and the Tennessee Senate signed off, and it went to the governor's office, he signed it, everything's all done, it would not be law until January 1st, which is the next day come on, and then it would be enacted.
Okay.
And then the same thing happens on July 1st.
That's interesting.
So I often tell people that if the 5-year rule ever changes, here's the way it's going to change. The feds will change it in the Medicaid Act, all right? And they will offer money to the states to adopt the change. Because when they change the Medicaid Act, the states don't have to opt into it. As a matter of fact, when the rule changed from 3 years to 5 years, only 49 states opted in, one did not, and to this day. So if they make a change like that, the states can opt in. But they usually always do because they say, we'll give you more Medicaid money if you accept this change.
Right.
Kind of like a bribe, I guess. It's a quid quo pro. It's not exactly a bribe, but because
Bribe is only illegal in politics.
That's right. That's right. And so if they did that, if they made that change and Tennessee adopted it, we would see it coming because They would adopt it, the legislature would adopt it, the governor would sign it, and we would know that the next time it goes into effect is
Right.
whichever one coming up next, January 1st or July 1st. So if they do that now, let's say they do that and they pass it all in November and all that, we know we got a month or two notice when it's gonna be law.
Sure. That's interesting.
And we will know, and I'll be busier than a one-armed paper hanger, so to speak, when it happens. Everybody's gonna try to get in under the wire.
Everybody try to get in. Yes,
But,
right.
but you know, and be honest with you, in all reality, I spent the last 4 years I'm shocked that the last administration did not change that time period. They thought about it twice. They started one time it was looking at 7 years, one time they were looking at 10 years. It just never developed enough steam to get. It just kind of fizzled out. There was discussion about it. There was a couple hearings in congressional Ways and Means Committee type thing. They talked about it, but it just
Who would, in your opinion, I guess, and you may know, who would bring that up and push that as an issue?
You mean like an individual?
Anybody?
I don't know. Usually it's a congressman or a senator, that brings it up. I mean, they're the only ones that can bring it
Yeah,
up.
they're the ones. But I would think there would be some force behind it, something
Well-
that says you guys need to look at this, and then they get some senator to take it up or some congressman
A
to
good
take it up.
example. A good example is like back in 2006. I think it was 2005. We adopted it in 2006. But in 2005, the feds came up with the Deficit Reduction Act. Okay.
Yes.
And the key word there is it wasn't our deficit they were trying to reduce. It was theirs.
It was theirs.
It
That's
was
right.
theirs. And the way to do that is to get more money.
Get
somehow.
more money. Get more of our money.
That's right. And so there was a lot of that. But that was where they took away a lot of the planning tools that we could use. That was before I started doing estate planning. But as I look back on it, there were a lot of neat things we could do that we can't do anymore. So, but one of them was they changed that rule from 3 years to 5 years. Okay.
Okay.
And by doing that, there's more property available in estate recovery, and there's more. You know what I mean? So
Yes.
they've created additional property. Now, I don't know. I could go back and look who. Somebody will sponsor a bill. Congressman can come out in the lower house, it can come out in the Senate. I'm talking about the state. I'm sorry, I'm talking about the feds now.
Right.
And they will sponsor a bill. Now, how that gets started, I don't know. There's probably a lot of minds behind it. And they come up with it. And then it goes through they propose a bill, and then it goes through the process of picking at it, messing with it, picking and choosing stuff through the House and stuff, and then it finally goes to the president and gets signed. Now,
Yeah.
this is the heads up we're going to see, because when that happens, it doesn't apply to any of the states yet. The change. It's just a change in the Medicaid Act. Then the states will start to opt in after that. So we'll see it coming way ahead of time when it happens.
Right.
But my original point was I'm just shocked that, because that's the past administration spent money like nobody's business, and debt was a real concern, and heading into deeper debt was a real concern, and so they're looking for money anywhere they can get it, except for good places like tariffs. But
Yeah.
but they were they're trying to get it because they needed it, and I just figured it was a matter of time before they get there. So I waited for that shoe to drop. It just never did. Now
Yeah.
I think it won't for a while,
Yeah.
and it still may happen, but I think we got a lot of breathing room now, which is great. Because now we're generating a lot of money by other sources, and they're
Right.
not strapped for money. We're actually gaining on it, which is good. So I don't worry about it too much. But again, if it happens, it happens. But it probably will in the future. It probably will.
Yeah. Okay.
But so I'm sorry that's not as good an answer as you wanted, but that's the process.
Very interesting, though. You mentioned estate recovery. Sparked my interest a little bit because I run into that.
You probably see it a lot, yeah.
I run into that, and I didn't know. You may or may not want to comment on this because it doesn't directly. I guess indirectly, it's part of what you're involved in. But can you explain how that works?
Sure.
How estate recovery actually is put into application?
And I do want to explain because it is something we deal with a lot. So,
Yeah.
Estate recovery is a real sleeper.
It is.
Good
It's
word.
a sleeper.
It's a disadvantage to people who apply for TennCare, and you don't know about it. However, I don't know, when we were dealing with your father-in-law, you got the letters from TennCare, right?
Oh yeah.
And they're like 18 pages long.
Yeah.
And 7 of them are stuff in 7 different languages, right?
Yeah.
But every time you get a letter, there's one in there that says about estate recovery. I
Yes.
don't know if you remember that or not, but it's in there. It's
Yes.
a page long. I think it's maybe front and back of a page. And it's a very brief overview of it. But what estate recovery is, and let's just back up to the very beginning. In the Medicaid Act, all states were required to have an estate recovery program. Okay?
Yes.
Now, estate recovery is how you get money from an applicant. They don't go after anybody that, other than people that have been on Medicaid. Now, let me just fine tune it and talk about Tennessee only. So, in our,
Yes.
remember, our version of Medicaid is TennCare.
Right.
So, if you're, it has nothing to do with you unless you get on TennCare benefits.
Yeah.
So, and I talk a lot about eligibility for TennCare benefits. That's where we spend a lot of our time. But when you're getting eligible for TennCare benefits, you got to keep in mind way in the future when the Estate Recovery Act's going to come in. Because in a nutshell, what estate recovery says, at your death, okay, so let's take me, and if I'm in TennCare for X number of years and I pass away, at my death, estate recovery is allowed to come after everything in my estate to the tune of the bill I racked up with TennCare.
Yes.
Now, let me ask you a question to you and everybody listening who has given this any thought. I'm taking it, you didn't know.
Yeah.
I'm trying not to be facetious, but it's one of those things that if it wasn't so serious, it'd be funny. But
Yeah.
did you know that if you get eligible for TennCare and they pay your bill, which is the goal of eligibility,
Right.
that at your death they want paid back?
Yes.
It's a loan.
Yeah.
It's not a benefit in a way. They call it a benefit. I don't get the benefit part. They want
Yeah.
paid back. So let's say we get somebody eligible, and they're eligible, and TennCare is paying their bill, and they're doing it for 2 years or so. They rack
Yeah.
up a $200,000 bill, whatever it works out to be.
Right.
That person passes away. In comes estate recovery, looking to see what's in your estate, and they want paid back every penny that they shelled out for you since you became eligible.
Yeah.
It's a loan. It's not a TennCare benefit. It's kind of a loan.
And if you have that much
If it-
assets in your estate or more, they will
If you
recover.
have anything in there, they'll go after it, and that's
Yeah.
what their job is to do. And they have to have an estate recovery program by federal law.
Okay.
Now, so when we are getting somebody eligible, we think, well, I'll give a prime example here. But when we're doing some eligibility, we got to think about, what about stuff that's still in the estate? What good is it to get somebody eligible? And in other words, if you can't get eligible, you'll get cleaned out because you have to private pay until you have nothing left.
Right.
And then on death, there's nothing for them to go after on estate recovery.
Yes.
But if you have something and you try to protect it, you can get eligible. But if it's still in your estate, they'll come after it at estate recovery. Okay. So, when I talk about the rules being complicated, you see this coming. This is a difficult situation to deal with. And here's a prime example. And that is what we call the primary residence. You're in real estate, and so your home, okay?
Yeah.
Now, primary residence is classified as where you live.
Yeah.
Because a lot of people own more than one piece of property. Now,
Sure.
there's only two categories when we talk about TennCare. There's the primary residence, and then everything else is called other real estate.
Yes.
Now, the difference between the two is all real estate is a countable asset. You hear me talk about countable all the time. Countable assets means available for the cost of care. So let's say you have a primary residence and you have an apartment building, not an apartment building, let's say another house somewhere.
Yeah.
The other real estate enjoys no protection whatsoever. In other words, it's a countable resource, and if you're trying to get eligible for TennCare, they will expect you to sell that house to pay for your care before you become eligible.
Right.
Now, the primary residence, where you live, is a little bit of a different story. Because under Medicaid Act, whenever you apply for care, you have to always declare an intent to return home. That's just part of the rules.
Yeah.
And when you do that, that's the reason we have to declare the intent to return home. Even if Aunt Gertrude has 0% hope of ever coming home,
Yeah.
we have to declare that in the eligibility process.
Yeah.
And because we have to do that, that puts the primary residence in kind of its own little status. Because if we have an intent to return home, there needs to be a home.
Yes.
Although, surprisingly enough, you can have the intent to declare a home and not have a home.
Interesting.
It gets big. It gets interesting, doesn't it?
Yes, it does.
And so, now let's talk about this home, because this is a prime example of estate recovery. And I can't tell you how many people come into my office just shocked because this is happening, never saw it coming, nobody ever told them anything. You get that sheet in the letters, but it really doesn't say. It just kind of says, hey, if there's anything in your estate, we're entitled to use it towards the bill.
Yeah.
But I guess nobody pays attention to it, but, here's an example. When you
Well, it's hidden in so much legalese when you get those papers.
You know, it's actually the opposite with TennCare. Their letters try to put things in regular street vernacular.
Yeah.
For an example, and I don't want to lose my train of thought, but for example, I was going over the application in one of my shows and talking about all the ambiguities in the application, and there's a spot there where it talks about a helping person that is allowed to help you with your application. A person that can sign it. Here's what it says: a person who can sign the application for you with your consent. Parentheses, you're okay, stop parentheses. Y-O-U-R space, capital O, capital K. You're okay.
You're okay.
So is that legalese to you?
Yes, no.
I mean, it's that, anyway, so getting back to state recovery, let's talk about the primary residence, because the primary residence does enjoy an inherent, I hate to use the word protection, but it's a status, a specific status.
Right.
Now, here's what happens. You go to a facility, go to a nursing home somewhere. I guarantee you, nine times out of 10, if not 10 out of 10, they're going to tell you, don't worry about your house. You know, it's protected. It's your home. It's protected. Don't worry about it.
Yeah.
I mean, I object to the word protected. It's something, but it's not that.
Yeah.
And so what it is, it's an excluded asset. Okay, it's not exempt. It doesn't go away. It's an excluded asset. What excluded asset means is this. Let's say we have a nice round numbers, a $100,000 house. I mean, that's really not in the ballpark, but it's an easy number to talk about on the radio,
Right, okay.
So let's say a house is worth $100,000, and that's a countable asset, right? And, I mean, the real estate's a countable asset. So if you're only allowed to have $2,000 of countable assets, how are you ever going to become eligible because your home makes you $98,000 over resourced?
Yeah.
Right? And okay, now so because of that. And because of the intent to return home, they do not make you sell your primary residence to pay the bill. You can exclude it. And if the nursing home does your application for you, which I never recommend, but if they do, it gets you don't even have to say anything. They automatically exclude it. Meaning, what does excluding the house mean? It means we take it out of the countable assets column.
Right.
Remember, there's many categories of property. There's countable, there's non-countable, there's inaccessible, there's protected, there's exempt, there's excluded. There's many categories of property. So we're going to take the home out of the countable assets column and put it in the excluded column.
Right.
Now, it's still a countable asset. It's just not going to enter into the equation. So if they do that, now all of a sudden, I'm trying to get eligible for TennCare. My countable assets has just been reduced by $100,000 because they took it out and put it in the excluded column.
Right.
Now that may make me eligible. Let's just say I don't have much else. That makes me eligible, right? Now, now I'm eligible. I file the application. TennCare scratches it, sniffs it for 3 months, and then finally says, okay, you're approved.
Yeah.
And they go back to the day I filed the application. They pay the facility, but they should have paid them. And going forward, they pay the balance of my bill. You know, all my income goes to the cost of care, and whatever is due of that $10,000 a month, the TennCare pays.
Right.
And that goes on, and now I'm in the nursing home for the average, 3.6 years, I think, whatever it is.
Okay.
And I pass away. Well, I don't have hardly anything because you can't own hardly anything to be eligible.
Right.
And now, when I pass away, let's say I pass away and have a will. In the will, I say, leave my house to my 3 kids.
Yep.
What happens when I pass away, and after I've been in the nursing home for 3.6 years? Well, what happens is, TennCare, it's called the TennCare State Recovery Act. When they bring up estate recovery, now they're coming after whatever's in my estate. Now, I just told you I was pretty much broke to get eligible, right?
Right.
But remember the house? It is still there. It's still a countable asset. It didn't go anywhere.
Right.
What they did was they didn't use the value of it in the eligibility determination.
Right.
It's still there. I still own it. And guess what estate recovery does? They go after whatever I own in my estate. There's the house.
Yeah.
And they will, if I rack up a $300,000 bill after 3 years, they're going after the house and they can force the sale of it. Oh, God bless them. They'll let my kids buy it back from them.
Yeah.
And not only do they go after the house, I have a will that says my 3 kids get the house. Bureau of TennCare has a priority claim on that because they're the government. They come in ahead of everybody and get paid first.
Yeah.
That's what estate recovery. It's a real sleeper. And so now they're saying, listen, when Stan was in a nursing home, we shot out $300,000. We want it back.
Right.
But we can only go after his estate to get it back. He's only got a $100,000 home in the estate. Okay, we're going to sell it if you three kids want it, you can buy us out, but if you don't buy us out, we're selling it, getting whatever we can get, then we're gonna move on to the next poor schmuck.
Right.
Sorry, I almost said something I didn't want to say. And we're gonna move on to the next case, right? And so, people, but so when you're told your house is protected, and you say, and you just don't do anything about it, that's what you end up with. Even if you have a will that says, my house goes to my three kids, that's not gonna happen.
Is there a timing factor on this? Let's say that someone passes and their estate is now established, and they have left their home to their primary residence, their home to their two children. Okay, but the two children don't do anything with it. They're just, in other words, it's just sitting there. Who initiates, who decides when that's going to sell and when the parties will recover funds, or the state does the recovery?
The state finds out that you passed away.
Okay.
If there's a probate involved.
Okay.
So it's one of the heirs decides to do probate. They got a will, they want to do probate.
Right.
All probate cases, by law, we have to fill out what's called a 10-care release.
Okay.
And here's what we do: fill it out. We tell 10-care the person passed away, and they send the thing in, and 10-care looks to see if they forked over any money for that person. And if they have not, you'll get something in the mail that says, pretty short and sweet, says we don't have a claim on this estate because we never paid anything on behalf of them.
Right.
And it's a release, basically. And no court in the state of Tennessee that does probate. Probate can be either general sessions or it can be in circuit. Mm-hmm. But no court by law will close an estate without that release in there. But if they have paid on your behalf, mm-hmm. you will get like a 16, I've seen them as long as 32 pages long, itemized list of everything they did for that person. And they say, at the end of it, they got a total, and they say, we have a claim on this estate, the total is $266,000.
Yep.
And now you got a lien on the house. Now,
yep.
If you don't have a probate, they still find out because Social Security reports deaths to all the different agencies. So they find out. Now, there used to be, and I have to bone up on this because it's just not, never comes into what I do, because we avoid estate recovery.
Yeah.
But there was a statute of limitations of a year, and it started at a particular time, and there was a court case that kind of changed that significantly. And I'm thinking that they changed the year under what we call the discovery rule. And the year isn't until 10-care finds out that the person's passed away, because I guess you could play hide the ball if somebody passed away, and if they weren't involved in any government programs, how's 10-care ever going to know? Right. You know what I mean? But I think I think it's something like that. But I'm a little bit out of my lane. It's just one of those things that never really comes up in my practice. I remember reading it a while back, but I just don't remember what all it was. Yeah. Because what we do is we get people eligible. We were thinking about estate recovery. Yeah. And let's talk about that a little bit more, since we're already talking about it. And you brought it up. Yeah. The states, because this is interesting. The states of 50 states of the United States have there's two kinds of estate recovery programs in the country. Now, remember I said each state has their own set of rules, right? Yeah. Now, here's a classic example. Remember the analogy of the big bubble with 50 little bubbles inside of it? Yeah. Yeah. Well, the big bubble says you have to have an estate recovery program. Okay. Mandatory. It's not a suggestion. Right. Not a good idea. Got to have it, because that's how they recover money. Okay. And so, but the states can do whatever they want. And the states have formulated two different kinds. One is called standard, and one is called enhanced estate recovery. Standard means they can only go after what is in the probate estate. So, what would happen if you had a revocable living trust and you put your house in the revocable living trust, which is a probate avoidance technique? Yeah. It's not in the probate estate. Yeah. Okay. Tennessee was started out as a standard estate recovery state. And so it would be really easy to avoid probate. You just do a revocable living trust, put your house in it. Yeah. Or anything else, because the trust, all trusts are 100% probate avoidance, because they're governed by the trust code, not the probate code. So it's easy to do in the states that are still standard. It's a pretty simple thing to do. Yeah. But other states are called enhanced estate recovery, and that kind of means whatever they have under any format, including in a revocable living trust. They can come after it. Okay. Tennessee, I can't think of the year. We're standard, but now we're determined to be a hybrid. somewhere in between.
Oh, boy, okay.
This came from a court case. This
Okay.
came from our common law. It came from the court case, and pretty much the court, in a nutshell. I remember the case had the name Smith in it, but which is the only reason it was memorable. But the court pretty much ruled that if you pass away and you have any indicia of ownership in the home, it's
Yeah.
subject to a state recovery. So
Okay.
that kind of puts the, it's kind of made us enhanced, but only for the home.
Okay.
You know what I mean? So,
Okay.
So now we have to go to lengths to avoid a state recovery, make sure it's not in the estate at death, and then they can't come after it. So that's kind of. So so when we do our planning or eligibility for people, we're always keeping in mind the estate recovery effect that we're going to have, down the road, whenever that's going to be.
Right.
First of all, we try to keep we do the planning, like our asset protection trust. We do the planning so that the property's all been divested to an asset protection trust.
Yeah.
Which means it's now a non-countable asset. So if
Right.
you go into care, everything in the trust is non-countable. So when you go through the equation of countable assets, they never come up because that's not what the statute says. The statute says countable, and so it's not there. But if we have a home in there, we deal with that. In that process, there's a way to do it to protect it from a state recovery, so that it's not there when the person passes away.
Yeah. It's very fascinating, and of course, this just is
It's mind reading.
the whole reason that you are doing what you're doing here, and trying to inform the public on what their options are to protect their assets and
Yeah.
to protect their inheritances for their loved ones, those that they want to leave something to. There's options that allow you to do that and avoid some of this potential cost to your estate.
And all that sounds gloom and doom. It all sounds like, well,
It does.
shoot, there's no way we'll get to protect anything.
It does, and I guess I'm going to circle back to my question again. You answered it, but I'm thinking further down the road. Let's see. Here's what I had in mind. Let's say that this person, there is a lien on the estate, or a lien on the real estate, the primary residence, from the state recovery, from TennCare. But I don't, but as an heir to the property, I don't care if my sister lives in it for the rest of her life.
Okay.
And I don't want to sell it. So we're not going to sell it. She's just going to stay there.
I've seen that many times.
And so is there an indefinite period that can happen? I guess that's my question.
Well, if they get, I thought the question was how long they have to make the lien. But if, let's say they make the lien, let's say, okay, the
lien's
dad,
on it.
Yeah, dad was in the home, racked up $200,000 bill, they got a lien for $200,000.
Yeah.
I've seen that on several occasions where it just sits there.
Just sits there.
I mean, is there an enforcement process? Maybe, but I never see it done.
Yeah.
And I've seen people that come to me and we look into the chain of title and we find the lien and it's been in there for 10 years.
Yeah.
Now, that is certainly going to surface when you sell it.
That's what I'm saying. It will surface at some point. If you ever sell the property, ever want to sell the property, it's going to be there.
And it's collecting interest.
And collecting interest.
Now, they give...
That part I didn't realize.
I mean, nobody can claim they didn't know because they give you notice that they put the lien on there.
Yeah.
I mean, if you say, well, I never opened the envelope or I never got the envelope, that's not a defense.
Yeah.
I mean, if they're sending it to the last known address and you got stuff from them before, you can't... Ignorance is never... If ignorance was an excuse, you can get out of anything. I didn't know I was supposed to shoot.
I would never be in trouble if that was the case.
I didn't know I wasn't allowed to shoot my brother-in-law. But so they let you know, so you pretty much ignored it.
Yeah.
And now but now, good question, because when you have a debt, like typically there's like a 10-year statute of limitations.
Oh yeah.
I don't know. I would suspect it's subject to that, but you know what? There seems to always be a caveat when you're talking about the government.
Oh,
They have different rules. If I owe a debt to you, you got 10 years to collect it from me. After 10 years, you're barred by the statute of limitations.
Interesting.
But if the state, nothing comes to mind because I've not dealt with it because I don't do the probate part. But it wouldn't be surprised to find that the state of Tennessee has a different time period, if a time period at all.
Yeah. Yeah.
And they probably couch it it's in the public interest to do a state recovery.
Sure.
So we can fund the program, otherwise it'll go broke. Now, state recovery is interesting. When you think about it, there's a lot of things they don't go after because it's too much trouble. Now, as a matter of practical fact, there's some things they can go after, but they just don't because for what they get, most state recovery programs barely make it. As a matter of fact, there are 2 states that have tried to abolish their state recovery program. Now, as soon as I heard that, I thought they're got a little trouble with the federal act that says you have to have one.
Right.
But their argument was, we lose money. I can't remember the numbers, but it's something like this. It costs us $20 million every year to do the state recovery, and we only collect 15 million. So every year we're 5 million in the hole. We're better off not having it at all, right?
Yeah.
But
that doesn't seem to make sense to the government.
Well, during the election, there was some talk about abolishing it federally, the state recovery program. Now, I really question. I mean, that'd be great news because nobody would lose a house in a state recovery. That'd be great news. But as soon as I heard it, I tried not to get too excited because I thought that's how the program gets funded. If you take that away, the program is doomed to 100% failure because you can't get funded. And so I thought it sounds like a great idea, but it's just I don't think it's going to happen.
Yeah.
And it didn't. It fizzed away.
Yeah.
And even if the party that was promoting it didn't win, but I just don't think it would have ever flown. You know what I mean?
Right.
And now I didn't come up with the other 2 states. I want to say it was South Dakota and something else, but I get their point. I think it's an economic decision to say we can't do it. Why keep doing something that loses money? So there might be some reform on the state recovery portion of the Medicaid Act to help them make money on the deal instead of lose money, because that's the whole idea, is to recover the money spent. And now if you're losing money trying to recover it, so there's how the state company works practically, and there's how it works legally. It's more of a practical fact than it is a legal fact. Sure. And what they go after all the time is real estate. Why? Because they can always get something.
Yeah.
Now, one thing I failed to mention, let me go back, because if there's anybody at home right now that's just sweating bullets because I said at the death they come and take that home, if you have a spouse still living in the home, they will not come after it. I mean, God bless them, they will wait until your surviving spouse dies before they take your home.
Yes.
Isn't that big of them? Now, there's a couple of exceptions, like a dependent child that's blind, or children under 21 still living there. Kind of rare things, but they won't put them out. They will wait. And I've known the state recovery taking over for the house, and the surviving spouse lived 30 years.
Oh, yeah.
And then at death, there it is. Completely forgotten that was there. Yeah. But it surfaces.
It's still there.
Yeah. And so again, if you're thinking, oh my gosh, they're going to kick me out of my house because my spouse passed and was in care, no, they won't. They will let you live there. Like I said, God bless them. That's big of them.
And this whole thing can be completely avoided.
You can, with some planning.
With some planning. And that's what we're all about here on Friday mornings with the State Plan Stand. And that's why we do what we do. By the way, the phone lines are open, 766-9393. And it's been an interesting little discussion because I run into that part.
In real estate, I believe it.
And of course, we run into places sometimes where we're doing a sale and we find out that, in fact, there's a 10-care lien on this property.
I can just imagine, you got a seller. Has a price. You got a buyer. It goes back and forth a time or two. They agree on a price. Yeah. Start doing the paperwork. Hire an attorney to do a 30-year title search, right? Title insurance company gets involved to insure the title. They start looking in a chain of title, and whammo, we find a $150,000 lien on the house. Yeah. You talk about a monkey wrench in a sale. Oh, yeah. That sale is stopping that moment. Yep. I mean, now what do we do?
We got a whole new thinking process at that point.
The buyer's going to say, okay, I need to modify my price, but I've already made an offer and it's been accepted. Yeah. But of course, those contracts always, they have to be full disclosure. If you didn't disclose everything, then you can't say, well, it's not my fault, I didn't disclose it, I didn't know about it, because not knowing about it, it's not a defense. So that voids the contract. But yeah, everybody's ticked because everybody has their eye on their percent commission, and it's not coming now. Yeah, absolutely. But I mean, it happens from time to time. But if it surfaces soon enough, you can work it into the process. Yeah. In other words, you got a $200,000 house, got a $50,000 lien on it. I mean, that affects the price. Yeah. Somebody wants to buy it, say, I'm only going to give you $150,000 because if the lien's going to go with the house, I want to have $50,000 to pay the lien off, and now I'm still out what I was going to pay you. It's just not all going to you. Yes. So I mean, there's a way to work it out if you know it's there. Sure. And that's what the title search and there's no title insurance company that won't find that. There's just not a good substitute for really good information. That's right. That's right. I mean, they try to communicate, but people think if they ditch letters from the government or it went to a different address, they can claim, well, I never got it, so you can't hold it against me. And that's not, I mean, they don't have to send everything certified mail. A lot of things they do, but they don't have, but even if they do that and send it to a different address, if they can show that was your last known address and you haven't done anything to publish what your new address is, that's considered notice, whether you read it or not.
Yeah.
You know, you hear about people serving process and stuff, and they walk up to you and they want to hand you being sued, right? You know, they hire a process server to deliver it.
Right.
They walk up and show it to you. You know, you hear a story about somebody just put their hands in their pockets and won't take it. They drop it at their feet.
Yeah.
Okay, that is service because you've got it. If you choose not to read it, that's your problem because you.
Yeah.
You know, they can't make somebody read the thing. I mean, if you could defeat the legal process by simply just not opening the letter, that would
be a whole different
things
world.
would crumble pretty much, right?
Yeah.
And so you know, you just can't pull that kind of stuff for it to work. So claiming you didn't know it was there, I mean, is a bummer, but it's not going to get you off the hook of it being there.
Yeah, interesting.
Because notice to the principals, notice to the principal agents, notice to the principal. So you know, if you let somebody know, you know, like that this is going on, or even put it in the public record,
right.
That's notice to everybody. When you know, like the public record, like you record deeds, right? Everybody records a deed.
That's right.
Now, when you record a deed, what happens the minute they record that? The minute they record it, there is a presumption under the law that everybody has read it, knows it, and understands it.
Yes. Yeah.
So when they pass a new law, let's say pass a new law, I don't know, I can't think of anything, but they pass a new law and you don't even know about it. And you break the law and they come and do some penalty to you for breaking this law.
Right.
And you say, I didn't even know that law changed. I didn't know it was like that.
Right.
Well, that's not an excuse because when they codify the law, it becomes part of the public record. And so they notify the public at large. And so if you're part of the public, so you are assumed to know and understand what it says and what it means, and you know it's in effect. If that were the case, you can never, it's always always a defense.
A lot lesser example, but you can't claim you didn't see the speed limit sign.
Yeah, that's right. It's posted.
It's posted.
No, if you can't see that, you shouldn't be driving in the first place.
I didn't see that. I didn't see the speed limit sign, but that's no excuse.
That's right. That's right. I'm sure many folks have tried that. I remember one time, years and years ago, I pulled over, and, I don't know, I was 55 and a 45 or something, and I just made the comment that I just wasn't paying attention to my speed. Of course, that didn't work either.
That didn't work.
I knew it wouldn't work, but I was going for the sympathy part. You know what I mean? You know, cut me a break. I just was. I was just zoning out.
Well, the officer says, "You know why I pulled you over?" It's like, well, I hope it's a really good reason because I'm in a hurry.
That's a good one. I was taking a swig of coffee and I got choked on it. Make it quick. I'm in a big hurry.
I'm in a big hurry. I hope it is a good reason because I'm in a hurry.
You know, there's a book out by, you know, John Kennedy, the senator from Louisiana.
Yeah.
That guy is Mr. Cliche.
He is.
But he's fun to listen to.
He's very fun to listen to.
He made a couple of, he was talking about a book he has out. But anyway, he was talking, he said something like, this is one I love. He's, you know, I'm not going to get political, but this is one thing he said. He said, if you trust the government, you obviously failed history class.
Yeah.
You know, and
that's funny.
You know, and he was talking
and
about.
He's right.
He was talking about somebody who was very influential.
Yes.
He said that guy could talk a dog off of a meat wagon.
Yes.
That's how he talks all the time.
Oh, yeah.
I love to listen to him.
Yeah, he's quite comical.
You know, when you think about that, that really drives his point home better than any other way you could say it. Even though when you hear it, you say, I can't believe somebody as prestigious as a congressman talks like that. But I don't know anybody that can relay his point better than with those kind of whatever you call them.
Yeah, he's
and cliches.
I think some of the reporters have really picked up on it too because they have him on a lot.
Yeah.
You know, and they'll have him on a lot because he says some of that kind of stuff, and I think they really like to hear it. It's funny.
And it's not insulting to anybody. It's not like when somebody says, you know.
Oh, I've watched him in some of the hearings too, when he just tells somebody, "You must be stupid."
Yep.
You know, you must be the stupidest person I've ever seen. I've certainly, he's just pretty plain spoken.
Yeah. Well.
Oh wow. Oh wow. Well, you know, we've almost filled up a whole hour.
We have, but we talked about some good stuff.
And some good stuff. While we've got a couple of minutes, of course, your office is located in Pulaski, Tennessee, on the square there. And I usually ask you about the theater because there's usually something going on.
Good thing you brought that up because
Yeah.
I have a flyer. Miss Tammy wanted me to drop off. It's in the truck. I'll bring it back in and give it to LB or something.
Yeah.
But we've got, without that in my hand, but we've got something coming up real soon.
Yeah.
So not this weekend. Might be next weekend.
Okay.
But I'm short. Oh, it's called the 77 Experience.
Oh, okay.
And we got a person that's putting it all together, and it's not us putting it together, it's a group that is coming to our theater to do it.
Okay.
And they go, it's like a show that moves around place to place. And what they're doing is they're gonna showcase all the hits in 1977.
Yeah.
So for all of you in our time frame, I mean, I graduated in 73, but I sure do remember 77. But a lot of good songs came back, and that was somewhat the disco era and some other stuff that was going on. But a lot of good music, they're just gonna showcase that. So it's called the 1977 Experience. I don't have my glasses, so go ahead and read it.
The 77 Experience, Friday, October the 17th. Friday, October the 17th.
So it's next Friday.
So you can buy tickets online. You can look it up. The Star Theater is STAAR.
2 A's in Star.
Yeah,
That's right.
STAAR, Star Theater in Pulaski, Tennessee.
And it's
Just look it up.
.org. I think it's .org.
It'll pop up pretty quick if you just do a Google
Yeah,
search
I
on
think
it.
it's startheater.org. And yeah, there's 2 A's in that because it stands for Southern Tennessee Area Arts Repertory.
Yeah,
That's
Star Theater and 70s. You know,
So
I
week
would probably
from
really like that.
a week from today, right?
I'm a 70s music guy. I would probably really like that. Was my middle of my high school years, so
Yep.
I'm
Yeah.
sure I would like that.
But it's going to be a 2-hour show, and I'm sure they have a break in the middle, but it's going to just showcase the highlight songs of 77. You can go back, do a little walk down memory lane, hear that stuff, sing along.
You know, Teresa and I were just beginning to be sweet on each other in 77.
Hey, you can relive that.
That's right.
That actually would be cool.
That's right. It really
That would
would.
be cool. Dress up like 70, get your bell-bottom pants on.
My bell bottoms and my platform
Maybe your
shoes.
paisley shirt or whatever, paisley polka dots, whatever
Yeah.
they used to call them. You have to get away, can't grow your hair long, but
Yeah.
Anyway, yeah, that would be fun. I'm going to be there. It's, whenever I go to those things, I practically leave hoarse because it's just kind of like a big sing. It's a big sing along, you know what I mean? When you're in the audience.
That's awesome.
But if I have to disco dance, I don't know. I used to know how.
I imagine tickets are selling fast, so you might want to get a hold of those.
Yeah, I don't know what it is. I know it's not sold out, but
Yeah.
it will be. Things at our theater, the ticket sales are usually offered relatively early. You always got your diehards that buy them early.
Yeah.
But the sales tickets speed up as we close in on the event.
Yeah.
So last week is usually the biggest flurry, but.
Good deal. And it's right there on the square too, next to
when
your
you
office.
When you get to that thing you're talking about, there's a place there where you can purchase them.
That's right.
online,
You
which
can
is-
buy tickets right online,
which
right
is pretty
there.
much how we do it all the time. So.
That sounds like a lot of fun.
Yeah. And then next week I'll have some stuff that's coming up on the, there's some Halloween stuff. We're doing like karaoke it's adult karaoke. And the kids are doing something called the Bizarre Bazaar.
Yeah.
For the younger kids.
Okay.
And I'll bring something I'll drop that off because I think it has all that on there.
Good deal.
But later on in October for that.
deal.
So now that brings us close to.
Yeah.
So we got the seminar November 22nd up in Franklin. I'll give more information on that next week because it's still about 5 weeks out. But you can call my office to get signed up for that if you want to. And my office is 931-363-7222, Pierchoski Estate Law, or you can go to my website, estateplanstand.com, and we are here every Friday from 8 to 9 for Bulletproof Estate Planning. And I am Estate Plan
You
Stan.
are Estate Plan Stan. That's right. You can find him on the web right there, estateplanstand.com. And of course, located on the historic Pulaski Square. That phone number, 363-7222. Thank you, buddy.
See you next week.
Broadcast services.
Good times, right on.
Communication